Iris, there is a real issue. There's a real issue with regard to harmonization, especially in our country, for instance. Let's take an e-commerce website whose domain name may be registered with a registrant based in Europe, and it may be having a flourishing business in India. It may be a well-known mark in India, but it may not be recognized as a well-known mark abroad. And there may be similar marks available with that domain name registrant. Then there is a major problem because that mark is given to someone else also internationally. And the server is based abroad. Even if we keep on passing injunction orders, we are not able to deal with the source of the problem or the source which is creating all these issues, because it is beyond our territorial reach. And we have to deal with it on a case-to-case basis. So it's really not solving the problem. The other issue is, and really that concerns public interest. See, harmonization, if it takes place, would facilitate international trade and transaction, as was flagged by some of the speakers. But it would also facilitate, availability of good technology across countries, and especially in the developing nations where you need very good technology. We may be starved of it in case we don't have harmonization and the trademark holder or the patent holder doesn't feel comfortable in coming to that jurisdiction. So it serves a larger public purpose also. Otherwise, you have a domino effect, as they say, a ripple effect, where good technology and good inventions may not be available for use. And the trademark owners and the patent owners may give that country a miss, saying there is not enough harmonization. You follow a different principle which we are not comfortable with. There's already a huge difference between civil law countries and common law countries. And I think rogue websites, for instance, is a major problem. And with servers being situated across borders, the parties who are mainly controlling the basic issues being based outside the territorial jurisdiction of the country, where the right is being exercised, has its own complications. So a little more harmonization on a few universal points, like registration, procedure to be followed. For instance, let's take procedures. That should not be an issue with regard to, say, registration of trademarks, having a common ground for, or a common procedure for registration of trademarks all over. A simple form could be agreed upon. I don't think that should be a major issue. So harmonization can be achieved in a number of ways, whether it's procedural, it is substantive, may be a challenge, but a few basic principles so that technology can flow around, the trade and transaction at an international level can take place with a lot more ease, and prosecution, especially in gross cases, like, as I said, piracy matters, or rogue websites, domain name registrations, where people are getting or squatting on names which are very popular or well-known marks in a local country, but may not be having an international reputation. That's a major challenge to my mind.